Whenever I meet business owners to advise them on their intellectual property law strategy, and specifically when we are picking names for their company or for that matter their products and services, most of the business owners are very stubborn in picking up those names which clearly show what their company or their product or their service does exactly. And this might be a great strategy as far as business is concerned, because you directly get to address the consumers and tell them what you do. But legally, this is not really a great strategy. And why is this so is what we will discuss in this video. Alright, so the first thing that you need to understand is that whatever name you pick, either for your company, your product or services, legally it is going to be considered as a trademark only, and it is always recommended that you get your trademark registered, despite the fact that it is not mandatory, because the registration has its own advantages. And I, as a lawyer who speaks to startup founders and business people regularly, realize that most of the people do not realize that securing a trademark registration is a complex, nuanced legal process that is governed by an act called the Trademarks Act 1999, which clearly provides which marks can be accepted and registered and which cannot be. And it is only once you go through this act, and specifically to the section 91B of this act, you will realize that why I said that you should not be picking up marks that are descriptive of the nature of the goods and services that you're using or you're producing, because this is an absolute ground for refusal of a trademark registration on the part of the trademark registry. So if you pick a name which is exclusively designated to show what your company or your products and services do, then it is very, very likely that the trademark registry will raise an objection to your trademark and will not let you secure the registration for your trademark.